Yeah, hi small business owners, it's Harpreet from Sharon Law Firm. Today I want to talk about in our series of videos about small claims process. So today I would be talking about filing a small claims in state of California and under the system of superior courts who mostly have small claims division. So I think we have previously looked in the previous video generic information about the small claims court and about the fees and what kind of cases typically goes in small claims. Today we will specifically talk about the filing process or preparing to file a small claims. So the most I think important thing to know in any kind of claim, regardless of small claims, it's who is your defendant, or who you have grievances against, or who is the person or entity who have not performed the agreement. So to know the identity of defendant is important. Is your defendant an LLC or your defendant is a corporation? Because that kind of a thing requires a specific name, because you have to put that on your complaint and make sure you're suing a right entity or a person. And also you need to know the address, and also I think it's always good to know if they are a business owner, and if you like to sue the business owner individually or as a corporation or any other entity. So these things are really very important to know the identity of the person, and you need to do little bit of research. If suppose it's a store, you can go to the your city, and also because there is always a division about business licensing, you can get who is the owner of this business, such kind of information. I think for bigger cities usually you can look online, but for some cities you have to inquire either over the phone or in person to make sure who is the business owner. And you want to also know the name if suppose this business is operated under some fictitious business name. So once you know the identity of the defendant or the potential defendant, you want to send them a demand letter, and this demand letter doesn't require any formal specific I think format. You just have to, the main purpose of demand letter is to just communicate that there is a dispute and you want certain things to be done so that you don't take any further process or court's intervention to resolve this dispute. So that's the main purpose of the demand letter. So you don't have to worry about that it needs to be some shiny demand letter and like some lengthy ones. It's always good, I think, to communicate detailed basis of your claim and what's the dispute about. And also I think it's always recommended to mention in writing, but if you cannot for some reason or another, it's always good to call the other side and communicate about your issues and let them know that this is my demand and I will file a claim in court, and so that my claim is resolved in an efficient manner. So demand letter formats, you can find it online, but the most important thing is always follow the specifics of your case. You just don't copy and paste things. And I think the very good resource you can find for demand letter, very generic for small claims purposes, you can go at courts.ca.gov website, and they have this tool which you just have to put the name of the defendant and the person you're asking or demanding money from. So those kind of basic information, and it will just, I think, generate a Word document or PDF file, and then you can just send that. So that's not a requirement like a formal demand letter, but that's one of the questions would be asked in the complaint. Did you reach out to the other side? about your demands, and you have to make sure that you reach out. And it also makes sense, like without reaching out to them, you don't know if they are willing to even pay you without you spending money, energy, and expenses to go through this filing process and wait for the hearing to know on the hearing that I have not even heard about this dispute, and I was just willing to give this much amount already. So why to, I think, get into that whole process without sending a demand letter? So it's more logical, and it's also the judge will also ask you, okay, did you reach the other side? So the next step in the process before filing, also to make sure in which court you want to file the small claims, because there are rules. Courts have jurisdictions. Like any court cannot pick up your matter. If you are thinking about, you live in Stanislaus County or defendant lives in Santa Clara County and you're thinking to file your claim in Los Angeles County, that doesn't make any sense. Like both sides doesn't live there. So the common rule is wherever the defendant lives or operates the business, if in this situation it's an entity, so you need to file there. That's the safest, I think, jurisdiction for the court, and this is called personal jurisdiction. And usually small claims have like a very broad jurisdiction for like any kind of civil case other than like family law, probate cases, or some other complicated civil law case, which include like a mass tort case. Obviously that's not for small claims. It's usually consumer disputes, contractual dispute about rental agreement, and those kind of things, which we have, I think, already mentioned in previous video. So the most important thing you want to determine is your court, and that would be only determined based on your relationship between the plaintiff and the defendant. Like what was it? Was a contractual relationship, and then you have to determine where the contract was created, where the performance need to be completed. There can be like multiple performances. So the important thing is that where the main part of the contract was need to be performed. So each sides can have their own argument, but the safest route to go is file the claim wherever in whichever county the defendant lives. If it's in the same county, good. Otherwise, just file in whichever county defendant lives, unless your contract was signed in your same county, and you can make an argument that contract was signed, because that's one of the grounds that you can ask the court to hear the case in this particular county where you live. If suppose it's a tort case, car accident issues, so either you need to file in the defendant's county, or you need to file wherever this accident occurred. So if it's in your county, you file there, or otherwise safest thing, if you are not able to understand where to file, wherever the defendant lives or operate a business. And then again, the most important thing is also to make sure that you have the basis of your jurisdiction covered, because once you file it, if it's too far away, the other side can ask the court to first postpone the trial date and have a hearing on the issue of change of venue. Based on an argument can be made like all the witnesses are in this particular county, all the evidence is in this particular county, so it would be like a burdensome and doesn't make logical sense to try this case in some different county where all these things are not present. So always the defendant can make that case, but if you file in defendant's same county, so there is no logical sense for defendant to ask for a different county. So just make sure you're filing in a proper court, otherwise your case will be delayed. You have to probably dismiss and again refile it in some other county and just go through this whole process. So the next step is which forms to use, because I think the good thing with small claims process, you don't have to draft anything special or on some pleading paper, because the main purpose of small claims is to provide a way for small claims and also for public to go through this process without hiring attorneys, or just hiring some specialized legal professional. So there are forms. There are forms for every bit of, I think, process or step you go through small claims. So your first form and most important form would be your complaint. And that's complaint, the form number is SC100, and I will show you that. So this is basically SC100 form, and it's just basically a 3-page form. If you include the instruction, it just becomes 5 pages. So the first page, if you see, it's basically whenever you will file this form, the clerk will mention the date and put stamp on that this is your trial date. You just go to that date. And on the second page, you just mention the plaintiff's information and then the defendant information, and just make sure if there are like multiple plaintiffs and defendant, you just mention that. And the next, you have to mention about how much is the amount owed and like what's your claim, because as you know, I have explained to you in the previous video that the small claims court have restrictions on the amount how much you can claim. If suppose you have a case where you would probably can have a good claim of $20,000 and you bring it to small claims, then and it's adjudicated, you win $10,000, then the judge will probably ask you in the hearing, are you waiving that about $10,000, and then we can continue with your trial. So just make sure how much is your amount, and then you have to provide your story basically, like what happened, when it happened, and also how. So what's your calculation method, how you come up with this $10,000, so that the judge can, before your trial, can have some insight about your claim. And also I think there is space, because there are only like couple of lines, so it would be difficult to explain your story. And I always recommend that you file a declaration or additional sheet with this form to explain your story, because it's always good the judge has the written additional sheet or a declaration from your side, so you are putting the whole story up front. Because sometime what happened, you fumble maybe in the trial, or you forget some things to note out. But if you have already written all those things and presented to the judge ahead, then I think the judge will also remember all these things, because there is no court reporter in small claims cases usually. So no one is noting down all the things. So because judges have like a lot of cases to deal with, so it's always good to mention all your arguments in writing. Either there is some other code you want to mention, some case law, or just want to lay out all the facts and also attach your exhibits. So that provides the judge a pre-trial insight into your complaint. So once you complete that, then obviously the next page, the page number 3, will ask you about, did you meet to the other side? And so as I was mentioning about the demand letter, so if you have sent the demand letter and you didn't receive response, or the response was not proper, or they are not willing to give you the money you are asking for your claim, so you just mention that, I'll just reach out. And so the next is about the jurisdiction. So you have to provide the court a reason why this is the court for your case. So there are like different reasons, as I mentioned already, like where the damage happened, that the contract was made in this county, or it's a lease, or different kind of reason. And there is also other specific reason if you want to make an argument that like all the evidences in this court and all the witnesses are from this county. So you can just specify that there is space for that. So then you have to mention about your zip code, and also you have to see if this dispute is between attorney or client, because there are some rules to deal with that. And also if you are suing a public entity like a city, then there is a prerequisite procedure you have to go through before you file your claim, because you have to file first your claim with the city, especially if it's a tort claim. Already most of the cities have like a specific form. You can contact the city department or city manager's office and just make sure, or if there is a city attorney's office, usually there is, so you can just contact them and ask for the form, and you can just send that and you just wait for certain time frame. And if you didn't receive the response, then obviously you move forward and file your claim. And the next is, if you are filing like more than 12 claims, then as I mentioned earlier, your fees will increase, and also your total restricted amount, like the maximum amount you can claim in your small claims case, that would go higher. So, and also the next thing is, if you are filing the claim, if it's about 2,500, and if your claim was about 2 claims, then you have already understood that it's 2,500 amount, and then you just sign it and just go to the court clerk's office, which is usually you have to file in the civil division. You just file your SC 100 form and also the declarations or attachment with it, and you are done. You will get a date. You just prepare for that date and prepare your story and just wait for the response from defendant. Defendant doesn't have to file any answer in a small claims, because usually in civil cases defendant has to file the answer. But in this situation, small claims, because the legislature don't want to make this process again quite lengthy, where you wait for some response, you didn't get the response, and then so all the responses, you just go to your hearing, your trial hearing, and you get the response from defendant. So there is no more paperwork. Once you file it, you just file it, and then you wait some time. Defendant files something, which we will cover in the next video, like what can happen between once you file your claim and before your trial hearing, what other procedure is involved, because there's not much, but I like to discuss. There are few things either defendant can do or plaintiff can do if there is some conversation happening with defendant, and if you like to move forward, so what steps you can take, and there are like specific forms for that. So for this video, I think I have provided you a brief information about how to file the small claims and about the complaint, and which are the things you need to make sure before you file your claim. And in the next video, I will talk about the next step in the small claims process. Thank you for watching this video.